street. And it's instituted to sort of silence our truth tellers and our whistleblowers, our journalists and our activists. And it is part of an arsenal that is, I think, wanting to sort of, for those who want to silence truth and to evade accountability. And so they tie up our journalists and our activists in very long, drawn-out cases that are very expensive. But I think we also need to understand what's going on with slap suits in a broader context of intimidation. And George Orwell writes about how in a time of deceit, telling the truth is a revolutionary act. And when we look at what's going on in South Africa right now, this sort of persistent and pervasive culture of intimidation against our activists and our journalists and our whistleblowers, I think it is important to try and find ways to respond and react to this, because I think it is going to heighten up and get worse as we see a shifting political context. You know, we've sort of been in this environment where corruption fighters and whistleblowers have been gunned down and intimidated. But as we were speaking about the police earlier, we also see those who are being branded at the moment as whistleblowers and truth tellers calling for journalists to be sanctioned and imprisoned and dealt with appropriately if they get it wrong. And so we are at a very critical time, I think, in our democracy, but also in the world, where it is becoming harder to be a truth teller. And it is a revolutionary act, especially in the face of intimidation. So I have the very deep privilege of facilitating this discussion today with two amazing legal minds. We have Dario Milo, who is one of our country's foremost media and constitutional law expert. For the young people in the room, he is the OG, the GOAT of free speech law. And so if you're doing media law or journalism, etc., he's the guy that you're often quoting in your essays. But we also have the very brilliant Michael Power, who is a human rights lawyer and the MD of Alt Advisory and the chair of Power Law Africa. And Michael does a lot of amazing work, but he's also focusing a lot on media freedom, tech accountability, digital rights, and so much more. So we're not short of expertise on this panel, and I'm hoping by the end of this session we'll understand how slaps are being used to intimidate whistleblowers and journalists and activists, but also how our jurisprudence is developing in order to respond to this. And that we are also going to use this as perhaps a soft launch of a really cool tool that the MMA is going to be releasing soon called Slapback, which aims to be a resource for those who are facing imminent threat of slap suits. So we're going to kick off, and Dario, we'll start with you. And I want to start with the basics, because I'm not going to assume that everybody understands what slap suits are. So can you just explain to us what is a slap suit and how it's being weaponized, how the law is being weaponized against journalists and whistleblowers and activists?
Thank you so much, and it's a great privilege to be here, and particularly to be here with Justice Majid, who is one of my free speech heroes. And I'll come on to the slap decision that he authored later, I'm sure, in our discussion. Yeah, I think for once, you know, acronyms are always quite tricky, but for once the SLAP acronym is actually quite appropriate because it stands for strategic, and each of these words, you know, when you unpack it, tells you what it's all about. Strategic lawsuit, because it comes from America, against public participation, or strategic litigation against public participation. Strategic in the sense that in the mind of the claimant, the plaintiff, the applicant, the person seeking to, you know, stifle the expression or the participation, the strategy is exactly that. It's to chill speech, it's to stop public participation, it's to stop critical commentary. That's the strategy, that's the sort of mindset of the claimant. Often in the form of defamation lawsuits, but not only defamation lawsuits, any sort of weaponizing of the law in a way that's been characterized by the Constitutional Court as an abuse of process to achieve that strategy. And it's targeted against public participation, which is, you know, this often happens in the context of investigative journalism, but in fact the SLAP concept originated because of environmental protests in the United States and protection against you know, corporates and mining companies and others who were seeking to stop environmental criticism. So any truth teller, human rights defender, trade unionist, a blogger, investigative journalist who is targeted by the powerful, because often the slapper is a powerful member of society, whether that person, that entity is a corporate, an individual, politician, businessman. We've seen examples of all of these categories of people. I would just say one other thing by way of introduction, which is that you can have the best media laws on your books or in your case law, and yet still need slap protection. And I think the United States is a great example of that, because they're the leaders in the field of sort of protection, First Amendment law, defamation laws that benefit from a very high threshold of actual malice before you can recover against defendants like the media. And yet, even with those very protective defamation laws, there was a need for a slap architecture to develop, and it has developed in about 35 of the states in America. I would say that even with that development, you can see on the ground now in America that despite great free speech laws, there is massive intimidation, censorship, deference to the executive branch. You see in the attempt by the Pentagon, for example, to pre-approve anything that's published about it. So I think the lesson there is, one, even if you've got good media laws, you still need, I think, slap laws. Two, that even when you've got slap laws, you still need, obviously, to always be vigilant to protect these kind of rights on the ground where they matter most.
Thanks, Dario. I read a speech of yours in preparation for this, and you speak about the 3 M's, mineral sands, Morn, and Mazotti. And I just wanted you to touch on those 3 separate cases, but how our jurisprudence has developed as a result of that.
Yeah, in fact, there's a 4th M, Mafia, the Alex Mafia case as well now. But let me deal firstly with mineral sands, and Justice Majid is here to correct me when I get it very wrong. Mineral sands is a fantastic case, and actually a precedent-setting case worldwide, where a Australian multinational corporation, mining corporation, brought a number of lawsuits against various activists. Some of them were environmental lawyers, some of them were social workers, others were environmental protesters, all of whom were saying, broadly speaking, to various degrees, that this mining corporation's activities are a matter of concern on the west coast and the wild coast of South Africa. Brought these massive defamation claims. I think one of the defendants, John Clark, was facing claims in about 5 or 6 different suits of about 10 million rand. Webb Wenzel acted for them on a pro bono basis. And we, through the Budlanders, Jeff and Stephen, as our counsel, we took the point that there should be a defense in South African law, which is the anti-slap defense. And that eventually went all the way to the Constitutional Court as a preliminary issue. And this is not on the merits of the case. And the Constitutional Court unanimously, in a judgment penned by Justice Majid, said that worldwide recognition of anti-slap can be housed in South African law under our abuse of process law. And effectively said, and I'm probably completely simplifying it, this is when I teach this case, I say, effectively the answer was bad merits of a case plus bad motive amounts to a slap. So you've got to prove as the defendant that the claimant has engaged in a bad motive, in other words, an ulterior purpose, not to vindicate reputation, not to vindicate a particular right, but to stifle expression. That's the motive. And the merits are bad, because if you look at the actual cause of action and the potential defenses, they're bad merits as well. And once you've got that, you can plead a anti-slap defense in common law. I would say that even the judgment itself recognizes that the kind of detail that you get in foreign jurisdictions emerges from legislation. So I spoke about the 34 United States jurisdictions. There's great anti-slap law in a couple of provinces in Canada. The EU has just passed an anti-slap directive. The UK has sort of limited legislation now on slaps. To get that level of detail, you do need legislation. So I'm a big proponent of slap legislation, although I think mineral sands, symbolically and jurisprudentially, is a fantastic development to highlight the importance of regulation. The Motti case, or Mazetti management case, was, of course, an egregious abuse of process. And the amici in that case argued that it was a slap. Justice Roland Sutherland, didn't go as far as to say this is a slap, but he found this was an egregious abuse of process and awarded punitive costs in favor of Amabongane. Everyone will remember this was the ex parte application, and I stress ex parte application brought by Mazzetti, the company, to get the leaked documents and leaked files that had been made available to Amabongane by a source, a whistleblower, to get that returned to them within 48 hours of the ex parte judgment. And eventually the Johannesburg High Court, the Deputy Judge President, highlighted that that was a great abuse, that was an egregious abuse. I think it's a great example of a slap, it's my opinion. And the Morn case, of course, is so important for various reasons. The first was, this was the private prosecution by our former President Zuma against journalist Karen Morn for reporting on his corruption trial. And that's the Shabir Sheikh-related corruption trial, not the Gupta corruption trial, which is far off, I'm sure, still. And in that case, what Zuma argued when it was put to him that this was a slap, this private prosecution, is, well, mineral sands is about defamation and it's civil law. This is a criminal case, so it doesn't apply. And I think, importantly, the court firstly upheld it as being a slap. This was the ulterior motive of former President Zuma to stifle commentary about him. The merits of his case were bad because Karen Morn had, in fact, not breached any legislation. And then, importantly, the court said that it applies, that reasoning applies beyond civil cases, also to criminal cases. And, of course, some of the worst consequences of the pressure that truth speakers feel is from criminal sanction as opposed to civil sanction. So I think that's a great development as well.
Thanks,
Thank
Dario.
you.
Thank you. So, Michael, I just want to touch on what Dario was saying, and coming from the mineral sands judgment, which is that slaps don't exist in isolation. They're part of a broader sort of pattern of abuses of processes. So will you be able to explain to us how this intersects with other forms of legal intimidation, like prior restraints, protection orders, or interdicts?
Sure. Thank you, Kavisha. Thank you to the MMA team for the week. And then just to acknowledge, it's not following a constitutional court justice and someone who I once clerked for, and then undeniably the OG of media law in South Africa is not an easy act. But I will try my best. You know, picking up where Justice Majid left it in the jurisprudence, and that was quite a narrow case in mineral sands. It was about a special plea in a trial. I think since then there's been a few developments. Mazzetti was a big development, and there Sutherland, we were for the amici, we were representing Media Monitoring Africa and SANEF, and he puts in footnote a slightly extended definition of a slap, which I want to read to you, and he characterizes a slap suit as the use of the, he says, the use of the label has widened beyond its literal meaning to refer to, one, any legal proceeding by a well-resourced entity aimed at harassing a vulnerable person or entity, and two, doing this to outspend them in litigation and thereby forcing capitulation. So, you know, the de facto position, and I would happily debate this with colleagues, is that in trial proceedings, in special pleas, the Concourt has clearly developed how you plead a slap suit at the early stages of a case. Justice Majid says in his judgment that he's extending our abuse of process doctrines to include the strand of slap suits. But we're starting to see the use of the slap term in other areas. Now, whether or not that is correct in terms of jurisprudence is one question. The power in the word slap is that it is a form of a public defense against a well-resourced actor who is abusing a court process. So what we did in that case was we suggested that there were elements of a slap, and I think Sutherland was correct not to find that there was a slap, but we were making that argument to see where the jurisprudence would go. There was a case that followed Sutherland's called Ray Capital, and that was a well-resourced property group based in Europe who sued the Mail and Guardian. And what they sought from the Mail and Guardian was what's called a prior restraint on publication. And again, Dario is the OG on these strands of law, but we were on that particular case. And what had happened there is there was a Ponzi scheme or allegations of a Ponzi scheme, and there was arguably a link between this scheme and this actor. Mail and Guardian was reporting on the story. This actor came to urgent court and said Mail and Guardian needs to stop reporting on the story in perpetuity. We represented Mail and Guardian, the editor who was cited as an individual, and the journalist. And we successfully got the matter kicked out of urgent court. And what we said there was that this case may not be a slap for the purposes of our jurisprudence, but it encapsulates some of the fundamental elements. The judge didn't go on to write about slaps, just discarded it on the basis of urgency. But we are starting to see this iteration, and it's a very interesting discussion. I would have a debate with Dario about where we locate an anti-slap law in South Africa. I think it's a good conversation. But what we are seeing is clear Concord guidance on trial procedures, and we're starting to see the use of the word slap emerging in other procedures. So there is clear jurisprudence on prior restraints on publication of journalists. It's a no-go. Don't go there. We're also starting to see actors using protection orders. So there was a good discussion earlier about protection orders for bona fide, for good reasons. We're now starting to see malicious actors protecting back, so to speak, and getting reverse protection orders saying that you're harassing me, a journalist. By phoning me for a story that constitutes harassment, I'm going to get a protection order against you. We're doing some interesting research as well, where we've got guidance from journalists saying that what a lot of figures in state are doing at the moment is alleging that protection orders are in place when they in fact don't exist, and using that to intimidate and silence journalists. So you have your very traditional slaps, which we've incorporated from US jurisprudence, as Dario has discussed, and the Concord has given us very clear guidance. Then you have a raft of actions generally against journalists, human rights defenders, activists, whistleblowers, which have the componentry of a slap. And the word I refer to is a word from a judgment, Satole versus Media 24. Dario was not on that. It's one of the cases Dario wasn't on. But there, Opperman J., who's now serving as an acting justice in the Concord, uses the question, is there a manifestly intimidatory componentry to the case? And as we start to grapple with what slap law is outside of trials, and as Dario's indicated that we're starting to see slap arguments raised in other fora, the question for me is always, is there a manifestly intimidatory componentry? Whether it's through a trial, a claim for damages, whether it's through trying to interdict and restrain a journalist or a protesting student, what is the fundamental intent? And it's that manifestly intimidatory componentry which we look into. The other unique element I just wanted to point out in some of the slaps that we've worked on is there's a few trends that I'm picking up. If you look at Mineral Sands, notwithstanding its international character, that was a private company in South Africa, not a public company. Mazzetti Management Services, private company. And if we look at another case we did, which was defending an environmental activist against Century Property Developments in Kyalami, equally a private and not a public company. So there seems to be a trend of private companies initiating slaps, and more so, private companies that are still founder-led. So for those who are looking to do some multidisciplinary research about the psychological or psychosocial elements of slaps, there's a very interesting story there. That would be one flag to look out for. Who is slapping? The second is, are you targeting an organization or an individual? So in the Ray Capital Mail and Guardian case, the interdict was clearly against Mail and Guardian because they were publishing. But they joined the editor and the journalist for no apparent reason and sought costs against both of those individuals. Manifestly intimidatory componentry. And the third is significant quantums. What you see in slap suits is these outlandish costs requests. So what we had in the environmental case we did in Kyalami was a group of activists were using our public law system to oppose development. They were raising objections within the town planning tribunals. The slap then suggested that because of these lawful objections, Century Property Developments had lost 197 million rands worth in fees for development, and that should be reclaimed from an individual environmental activist. It would be impossible to do so. it was also somewhat vague in their pleadings as to how they got to that amount. Second element, in Ray Capital, there were these vague and abstract accusations in the original application for the interdict, saying you have cost us between $25 million and 50 million euros. No further explanation, save for a statement that if you continue to publish, we will both interdict you and we will sue you for damages. Again, manifestly intimidatory componentry. So when we look at slaps, I think collectively as activists, those litigating in the courts, and it may come to the question about how we legislate this if we do, but there's clear jurisprudence on trials. How are we going to deal with all of these either slap or slap-adjacent type of claims that we're seeing coming through urgent courts, motion courts, and increasingly criminal courts? So Kavisha, I hope that gives a bit of clarity.
It
Happy
does.
to expand further.
Thank you. I mean, getting hit with a 197 million damages claim is intense. As an individual, is really intense. And I wanted to touch on about what's the human cost of these very chilling sort of litigation against people, and both of you can answer that.
Yeah, I mean, just to start, I mean, you see it when you speak to journalists who are subjected to, and sometimes they're the most, award-winning, sort of seasoned journalists or commentators or satirists as well. And you can actually sense in consultation the emotional toll that this is taking on them. Firstly, it becomes, of course, something they're living with. And they take it home at night. They don't leave that at the office. They live through that experience. Any litigation, if you are the target of the litigation, is not a pleasant experience. No one wants to be sued. No one wants to be put into a witness box and have the threat of damages hanging over them. Never mind a potential arrest and jail sentence for a trumped-up criminal charge. So there's, of course, a very, very human cost to this. But there's also a cost to the public discourse because, firstly, that particular media house is now focused on defending the case and marshalling very limited resources. We've heard about all the challenges to the media to defend the case. Even if you've got pro bono assistance, that can only go so far. But secondly, it also sends a message to other outlets, of course, to say, this is going to happen to you as well if you criticize us. And for me, one of the most important non-legal responses to slaps is, I think, the need for solidarity amongst, for example, the media, so that if one media company is being slapped, you have other media companies talking about it, publishing, perhaps joining the litigation as friends of the court, which Michael was talking about earlier. There needs to be that solidarity because just like it takes a village to raise a child, I think it takes a village to fight a slap often. Because you often see with the litigation a parallel strategy of intimidating the journalists or the truth tellers on social media. In Karen Moorn's case, there were images sent by President Zuma's daughter, for example, of Karen Moorn in prison wear, and when she was in the dock. And that image of her in the dock was sort of iconic for the anti-Moorn followers. So that's hard to deal with from a legal point of view. Law is a bit of a blunt instrument to deal with those consequences of slaps, and we have to think broader than law to address that. But huge emotional and human toll, I think, that these kind of lawsuits extract from truth tellers.
Yeah, I'd agree. I mean, just to know, we generally separate it into sort of reputational, which I think for any journalist, for their reportage to go on public trial, is something that causes anxiety. Whether or not they stand by the story is irrelevant. The fact that they're not on the ground reporting and that they're sitting in lawyers' offices consulting, there's already a cost there. There's obviously the financial cost. I mean, if we look at Ray Capital, there you had Lise Commons, who's freelancing for the M&G, who's now, there's this vague allegation that she's going to be hit with a 50 million euro defamation claim or damages claim. And that, I think, plays on the mind as a journalist. You are hopeful. South African courts, it is fair to say, have been absolutely fantastic in the defense of journalists. But it's before you get to that final judgment. There's this threat of 197 million rand, 50 million euros hanging over your head. And then the third is the emotive, and I think the secondary trauma that comes with it. One, there's this direct attack on you. But two, the trolls and the bots online then start hammering this home, right? And we've seen it with a lot of our clients, particularly there's arguably a very clear gendered lens to all of this. And particularly for women reporters, we see the secondary traumatization, not just of the fact that they have to go through a legal process, which is time-consuming and hard, but also in the social media space, they are ruthlessly and relentlessly attacked for either fighting for their rights or just by the virtue that a slap has been occasioned against them. So we see these three elements of harm, and I couldn't agree more with Dario that it does take a village to defend a slap. I think it's spot on.
I'm really interested in this idea of human cost, and I'm going to be slightly naughty at the moment because one of my absolute heroes just walked into the room, Cynthia Stimple, and more than just being the whistleblower at SAA, she's a whole bunch of other things and exceptionally wonderful. And Cynthia, I'm just going to come to you for a second, or for more than a second, to tell us about this work that you've been doing with whistleblowers, as well as yourself, and slap suits and tactics of intimidation.
Thank you, Kavisha. I see you've just thrown me there in the deep end. Greetings to everyone in the room. Sorry I'm late. I intended to be here by 11:30 as you asked me to come and see what's going on today. In my experience over the past 3 years, I've worked with whistleblowers at the Whistleblower House, supporting whistleblowers. And before that, even, I've been supporting whistleblowers in my own right. And what we've seen is that they are being charged with either trumped-up charges whenever they speak up in their organization or report anything. And if the company wants to keep them quiet, they will find something against them, be it you were late 5 days in a row this month or something, rather than the issue that was on the table. So the knock-on effect is that whistleblowers do suffer, as Dario mentioned, mentally. It affects you. It affects you that you're going to lose your job, you can't, how are you going to pay your bills, will I find another job? And then you're dealing with the current pressure of how do I get out of this mess? I have no lawyer, how do I pay for it? And even if they do get a good lawyer, chances are that the organization finds the top lawyers who will defend the organization to the hilt, look at issues of the personality of the person rather than the issue that's on the table. We've seen that with many cases. And so the whistleblower walks away or loses the matter. Where slap suits are concerned, people like Martha Nungoya, in her matter, even though she reported on the Shivamba case and stopped it, she was still issued with a separate matter to pay 147 million, which is still pending for her to argue with. Her matter has now gone to the Constitutional Court, and we're really hoping that that sets a precedent for whistleblowers in the future and to stop the slap suits. Another client who worked for Unilever, he got a slap suit of 150 million. He phoned me and he said, you know what? I'm going to laugh this off. I'm getting out of the country. And he literally went to London, and that's where he's working now. He decided he's not even going to deal with this. So it's becoming a habit, I think. It's becoming a weaponized tool to use against people who want to speak out against organizations or state-owned entities or any method they can find to stop you from speaking out. As we've said, it's the toll that it takes. It's the financial toll. You're not going to find a job. For my own, I have an MBA. I've got banking as my background. And when I left SAA, I was so confident I'd find a job. I did not. And only with that, I decided I have to reinvent myself, find my own things to do, and that's what I did. So it's really tough out there. And for the younger generation that are speaking out is whom I worry about, and especially the ones that we saw coming when I worked at the Whistleblower House, is how do we find employment for them? So I think the challenge is we've managed to, like with the Whistleblower House, PLAF, Corruption Watch, OUTA, many of those organizations are assisting whistleblowers through the legal side of the matter, through the media, getting their story out, like Dairy Maverick, News 24, etc. They also managed to get counseling for the whistleblowers. The challenge now is trying to find them to get back in the system, get employed, and to utilize them effectively. Thank you.
So, I mean, I think we all understand what the human cost is, sort of threat to your life, to your livelihood. And so we should take this, or understand this as an urgent space where we all need to organize around, that we need to provide solidarity to people who are experiencing this. And, Dario, you sort of wrote something about between 2004 and 2009, Zuma having about 15 defamation cases in court,
Yeah, that's right.
sort of seeing them as slap suits. And I can't help but draw those parallels to what's going on in America right now with Trump. I think there's a lot of, slap suit type litigation happening, also a lot of extortion that's occurring there. And so where we see the sort of patterns and trends of, authoritarian leaders knowing that they can abuse laws and courts and processes in their justice departments, or where big corporations can come in and, hit you with damages claims that they know you'd never be able to pay off or fight back. In this world where we're seeing a lot of democratic backsliding, these are the emerging and imminent threats, and with information ecosystems that are completely distorted in disinformation. So I want to take it back to democracy. And what happens to our democracy if we don't get this right? If we don't introduce, I know we have amazing jurisprudence and that helps us, and we have other laws that are, that provide protection, but people are getting smarter. They're becoming much more creative in how they're engaging in this type of intimidation tactics. And so what does that mean for democracy, and how do we chart a way forward?
Look, first, if I may, just on an anecdote, because you brought up Zuma's cases, and often when I talk to students and at these kind of audiences, they think I only do cases against Zuma. But that period, I remember it's just such a good example of how the law has developed favorably with the mineral sands judgment, is we were handling many of those cases which Zuma had brought against the media. And I remember that at one point we consulted Wim Trengrove and we said, we really need to perhaps try and consolidate all these cases and argue that, Zuma shouldn't have a right to bring them in this way. Because what he would do is he would launch the case, sometimes on the eve of prescription, and then just leave it hanging over the heads of the media. Millions, 5 million rand here, 4 million rand there. And remember, he was suing over cartoons, jokes. He was suing over opinion pieces, only one or two news stories, actually. And what Trengrove said to us is, well, the current state of the law is what you could plead is punitive costs, because he's basically abusing the legal system. And so in each of those cases, we pleaded punitive cost. But the sort of insight of being able to consolidate and substantively plead an anti-slap defense, which is what those cases were, in my view, has only really come about in recent times, in the last decade or so, with this recognition of slaps. And of course, the mineral sands case has made it quite clear. So that's just anecdotally, but I think it also illustrates when you have the most sort of powerful politician in the country, the president, suing willy-nilly for true reporting or for critical commentary or jokes, because that person is thin-skinned and wants their narrative and the disinformation that they are spewing out to be, to not be challenged. Of course, it harms democracy. It undermines public discourse. It undermines democracy. The ability to access courts in a way that you could swiftly respond to those kind of claims, I think really plays an important and pivotal role in our democracy. That's why our Constitutional Court has said such poetic things about freedom of expression, because freedom of expression lies at the heart of democracy. The question becomes, in practice, how do we sustain freedom of expression, not just from legal threats, because we have lots of tools to deal with that, though we need to sharpen them, but also from sustainability issues. You can't have a free press if you don't have a sustainable press. How do we deal with those threats to freedom of expression? Because democracy is equally imperiled by the sustainability crisis that the media faces now, as it is by potential legal threats. And that worries me, I must say.
Yeah, completely. Michael?
Yeah, thanks, Kavisha. I think it's spot on. I just want to, there was a piece of the mineral sands judgment where Justice Majid quotes Supreme Court of Appeal jurisprudence and then elevates it into Constitutional Court jurisprudence, just simply noting that there can be no doubt that every court is entitled to protect itself and others against the abuse of its processes. And that's where Justice Majid locates the whole slap defense within mineral sands. And for me, I think there needs to be recognition of political moments. You know, slaps, we shouldn't overbroaden that term. I think we need to keep the power that is associated with that term in defense of certain people. There are a raft of other abuse of processes that we see on a daily basis in the courts. Everything from misusing the rules, where there's two parties fighting about a television, all the way through to some of the Stalingrad tactics that we're seeing play out on a daily basis. And for me, given the right of courts to regulate their processes and manage abuses, I think there is a role for the judiciary to play here to meet certain political moments. I know a lot of judges in the US are trying. And I think it's obviously clear that a lot of judges in South Africa are trying as well. But there is an enhanced need for us to grapple as a community with the fact that we are, one, highly litigious. And because we are highly litigious, our court processes are somewhat ineffective in managing the volumes that we're experiencing in our courts at the moment. Now, there's a raft of work underway already. Justice Sutherland in the Gauteng local division here is putting in multiple practice directives to try and manage case flows, and I think there's a lot of good work coming out of civil society, deputy judge presidents, and elsewhere. Manifestly, I think the courts have this right, and they can enhance their regulation of abuse through increased punitive cost orders, and equally through the allocation of special motions. So the one thing that is unanswered after mineral sands is with mineral sands, you plead the slap defense, you still have to go to trial. Trial dates are now being allocated for 2031 in Johannesburg. So for all of those social reasons we discussed, a claimant has to sit with that for 6 years. What we need to start working on, and what Daria and his team in Mazzetti did very well, is using special motions. A special motion is effectively, you write to the judge president of a division, say, is there a spare judge? Can you hear us at a certain time and place? It's slightly more complex, but in effect. And we need to start using special motion procedures, particularly around abuse and the threat of abuse that is the slap suit. So I can see a lot of expanded special motions taking place to deal with these matters more expeditiously. And the biggest question now is that the law protects us, right? What we haven't solved is the amount of time and the time of lawyers that goes into defending these things, as well as how much time it takes the judiciary to process these cases. So both with enhanced sort of abuse of process procedures, particularly in our high courts, and potentially the use of an extended special motion role, I think we can push back. And I think this country can meet the political moment that we're in. So there are options. It just requires a lot of work and effort, and we can be appreciative of the steps taken thus far, but I think we can recognize that further steps need to be taken as well.
Yeah. And I think we just sort of take light from what Justice Majid said earlier, is that we always going through something as a country, but we are very resilient people. We have a very resilient civil society and media, and we will, fight these fights that we're going to be faced with. Michael, just before I open up to the audience, I wanted you to explain what the Slapback platform is. Speaking of resilience, let's go there.
Yeah, sure. So one of the mechanisms that can add to this burgeoning community was an idea of William Byrd. I must recognize that we're just simply on contract to help actualize it. But we're developing a web portal called Slapback. And it's quite simple. Effectively, what we've discussed today, we're putting online. We're detailing the types of threats and abuses of process that we see within South African courts. And we're also detailing what to look out for. This is what characterizes a misapplied protection order. This is where an interdict is inappropriate. This is a slap suit. We're then also giving an overview of legal defenses. How would an individual, absent lawyers, go to a court and make arguments to defend themselves? I mean, the benefit we need here at volume is if more individuals, particularly at the Madge Court level, can be empowered to represent themselves, I think we can move through a lot of these types of matters. So we're identifying all of the abuses, putting it on a sort of a fancy web template. We're dealing with how you would defend against these types of abuses. And then we're just going to create a database of the key decisions and judgments that are coming out of it. The fun anecdotal point of it is we're going to start a quiz. Some of these terms can become quite complex, particularly if you are the person defending yourself the next day in a MAJ court. So we're setting up a really nice interactive quiz where people can put in their particulars and kind of get a generated answer to put them in the right direction, but obviously that won't constitute legal advice. But that's Slap Back. It's a platform that MMA wants to expand over time just to ensure that there's public resources and knowledge sharing. It's looking to go live in the next month. I have no doubt that MMA will communicate it. But it really just is another element to this burgeoning community of legal practice, of civic practice, and of information sharing to better recognize the public about their rights and about this broad world of abusive process, inclusive of slaps, and equally to start providing remedies and how people can protect themselves against this type of conduct. So that's Slap Back in a nutshell.
Amazing. That sounds really great. And congratulations to MMA on another innovative idea. I'm going to open up for a few questions. I see Isak at the back. Nicole? Anybody else? Okay. Justice Majid?
Do we need an anti-slap law?
Nicole?
Thanks. My question, and I say this sort of conscious that I am a lawyer by training, and also much of the work of which I am most proud is that where I get to take credit for the work of other lawyers. But in looking at addressing slaps, we can't ignore the role that legal practitioners play in sort of designing and actioning these suits. And so you've spoken about costs orders, and obviously one can imagine that there are, the applicant claimant in these suits should be awarded costs. But are slaps not such egregious abuses of court process that they are instances in which the lawyers involved should be facing costs? And would that not be an important deterrent?
Thank you. Just last one, Justice Majid.
Thank you. I just want to, it's not really a question, but perhaps Dario can consider it. Well, both of them are lawyers, Dario and Michael. The one thing that we find at the court, and you will have seen it, is that we have these litigants coming back to the court all the time. And Mr. Zuma, unfortunately, one of them. We've just had a Mr. Oka, the night man, was accused of organizing an insurrection in Nigeria and fleeing to South Africa, having approached the court for the 10th time for the same relief. What our court can't do is to make use of the Vexatious Proceedings Act because of the way a court is defined. But I think lawyers must increasingly look at Vexatious Proceedings Act to stop these, this kind of abuse also as a further arrow in your armory. We can't use the Vexatious Proceedings Act. So what we've done now is we've said we regulate our own proceedings, and from now on we tell the registrar not to accept any more of your applications, which is drastic. And there's a split opinion in the court about it. But fortunately, I'm with the majority.
Thanks so much. Isaac, maybe I can address your question, which is really like a PhD topic. Do you need anti-slap laws? May I say first that just because I think the practical tool that Michael was talking about that MMA has developed sounds absolutely fantastic. I also would like to lay down a challenge to academia, and I think we also need more sort of deep empirical research on the prevalence of slaps in South Africa, because we can also document the lawsuits, but you also can't document very easily the letters of demand, the cease and desist letters, the letters that say, do not dare publish this letter. It's private and confidential, which so many people fall for. So I think I would challenge also some academics to perhaps do some really targeted research. That helps, by the way, when you try and develop laws. So it's linked to, Isaac, your question. Can I then say this? I do think we need anti-slap legislation in South Africa, and there are moves afoot. I know CALS has done a model draft law about a year ago. There are potential interventions with the African Commission of Human Rights to develop a regional approach to SLAPs, to regulate SLAPs. The reason I think we need it, and I've actually noted down what I think are the essential elements of an anti-SLAP law. I think we need it because although we have the broad guidance of the Constitutional Court about this being an abusive process, which it is, the development of the law was to locate it quite appropriately, given the nature of common law, as a defense. What does a defense mean? It means it's for the defendant to prove bad motive, bad merits. In practice, that's not very easy to do without having a full trial. And if you have a full trial, you undermine the rationale of trying to stop SLAPs in their track. So what you need is a law that provides for an early dismissal process. You know, as Michael said, sometimes you can craft a special motion to get into court early and ask the court to address a specific issue. I mean, in the Morn case, there could be a challenge to the private prosecution because that law allows that kind of challenge. But you need, I think, across the board, a provision of a law which says, here are the rules to allow you to get into court early, and this is a feature of all the efficient anti-SLAP laws around the world. There is an early dismissal procedure. You know, you can't have a 6-year waiting period for a trial. Second thing is the onus of proof. Because in South African law, it's a defense, it's for the defendant to prove. What the sort of, I think the best practice laws like the Canadian ones do is they have this threshold where the defendant, let's say the media, has to prove it's a matter of public interest, which is often a fairly easy threshold to meet in important stories, right? But once that's done, the onus shifts to the claimant to show that the claimant has a good case, has a reasonable basis for good merits, the defendant doesn't have a defense, and that in the balancing analysis, he or she or it should be allowed to proceed with their claim. So that would in a way, very substantively shift the onus, I think, if you have anti-SLAP laws. I think there needs to be provision in such laws also for costs on a punitive basis if you succeed in proving that it's a SLAP, because then you've proved that it's an abusive process, and this overlaps with Michael's going to address the question of Nicole about de bonus proprius costs. But I think an anti-SLAP law would give courts encouragement to say, I'm applying the law which allows me to award punitive costs. In my experience, courts are very reluctant to award punitive costs. I mean, just in some of those prior restraints that we were doing earlier this year, you know, even if you've succeeded in persuading a court that the plaintiff has brought this case as an abuse, you know, the matter was already in the public domain. What are you trying to interdict? The horse has bolted. And you've got a pretty good argument for costs. And in our case against in the Thabo Bester litigation for Netflix a few weeks ago, we had a pretty good argument, I thought, for de bonus proprius costs. The court doesn't go there. You know, the courts have to really be persuaded to award punitive costs, much less de bonus proprius costs. And I think, firstly, I think judges should be bolder and do it more often. But secondly, if you have a law that specifically provides for it, then the judge is simply applying that law once it's found that there's a SLAP. So yeah, I do think we need anti-SLAP laws, and I think we need them pretty urgently, actually. Thanks, Isaac.
Thanks, Dario. Isaac, I would support some type of mechanism. I don't know what it looks like clearly. I would be reluctant to start an entirely new legislative process, given the challenges we've seen with legislation coming out and the fact that on a termly basis now, legislation is being found unconstitutional and sent back for revision. I would look at amendments to the Superior Courts Act, potentially amendments to the rules of courts. So introducing it into law, but not per se through a new law, may be a quicker fix with the same intended result, given the urgency, which I agree with Dario on. So yes, I think there could be an expansion, particularly around getting it dismissed early. How we do that, I think, is a matter of strategic debate and where best we can get it more quickly implemented. Nicole, I mean, I was doing some research recently, and there's a wonderful article by now Justice Rogers on the Concord. He wrote it in 2017. It's called The Ethics of a Hopeless Case. And there he grapples with the ambit of what a lawyer should and shouldn't advise. I agree entirely with you that I think in some of the abuses we're seeing, there should be definitive cost bonus proprius orders. So for colleagues who are not in litigation, you get a normal cost order, a heightened cost order where the court is showing its discontent, but those are all against the party. And then the highest threshold is where the court says your lawyers must actually pay for this because they have abused processes to such a degree. I would agree it needs to be used more. The challenge always comes, I mean, if we use Mazzetti, which I think is a really interesting case, the legal team for Mazzetti briefed 8 advocates. I've never seen 8 advocates on brief, even in the most complex factual matters. 3 senior counsel, 5 junior counsel for an urgent court case. This was then against Dario and his team, where you had 2 counsel, you had Stephen and Isabel, 3. But the point there is that those lawyers were still doing their job. They didn't mislead the court. There were allegations of a previous order where there may have been, but in that case, they were simply doing their job for the client. And if they had to make an argument to the judge saying that they had advised their client that this was inappropriate, but they persisted, they're not acting in their client's best interest because they're already showing a sense of weakness. So the only thing I would change slightly is I would call the secondary hearings. If I was going to give costa bonus proprius, I would then ask the lawyers, after I had made a decision on the merits, to then explain to me what had happened and whether or not they are responsible, because then I haven't, so-called polluted the judge's mind with a view of weakness on behalf of my client. And I think that needs to be respected in the profession. So yes, I would award them more. And yes, I would agree, we're working on fee tariffs. There's a lot of jurisprudence coming out about it now. And I think now is a really opportune moment. Stuart Wilson just gave a really useful judgment explaining how much lawyers can actually be paid. And I think there's a useful time now, at least at the High Court level, to extend this around abuse. That's the one element. The other element is I think the Legal Practice Council has some work to do. I think we need to look at the writings of Rogers and others. I think we need to be sending guidances around to attorneys and counsel, reminding lawyers of their ethical obligations. And with respect, and some of the lawfare and abuse of process claims we're seeing at the moment, I think colleagues in the profession are overstepping the mark. And absent a cost order, I also think the LPC, through complaints procedures, has a role to play. And I don't think it has proved itself capable of the task just yet.
If I may just add to that with one tweak. The one is the Solicitors Regulatory Authority in the UK in 2024 passed guidance to lawyers, solicitors, in relation to what they can and can't do when they are approached by a client, and it looks like a slap is being envisaged. So I think you're right that we need the regulators to look at it. The other thing, I spoke to a corporate governance conference recently, and on slaps, and I made the argument that directors who authorize slaps could be held liable on a fiduciary basis as having breached their fiduciary duty to the company and the company's broader community and broader stakeholders, employees, shareholders, etc. And I wonder whether that may or may not be a good proposition as a matter of company law, but I wonder whether that kind of sort of lateral thinking, if it is lateral thinking, around other potential solutions could also be considered, because what you're essentially saying is sometimes you will have a large corporate bottomless pocket saying, I don't care if I'm going to lose this ultimately because it's going to cost them so much to get there, and maybe they won't even get lawyers to help them, etc. Let's do this. You push back as a lawyer by saying, well, first you can, as an attorney, you can at least say, I'm not taking your case. We don't have to, take cases for clients. I think advocates are a little bit more constrained with the cab rank rule. But I think if you have detailed guidance or jurisprudence developing around fiduciary duties in at least the corporate context, it galvanizes a sort of movement against bringing slaps and incentivizes lawyers and others to say, you can't do this. I'm going to be professionally in difficulty if I actually act for you in this case, and I have to withdraw. And of course, if they can just go to the law firm next to you, then it doesn't help. So it does need to be a universal sort of approach, I think.
Yeah, completely. We do have to try and find ways to de-incentivize this willingness to, go to hit journalists and others with slap suits because you're sitting on piles of money. Does anybody else have a last comment? Oh, there's more. Okay.
So I just wanted to tie the loop on Justice Majid's question around the Vexation Litigation Act. I mean, Judge, I couldn't agree more. I think it's something that needs to become a focus in practice, and it is certainly underutilized. And, you know, as Dario had said, you know, one of the next frontiers is enhancing this punitive cost audit jurisprudence. I think another frontier, at least at the lower court levels, is to invoke this piece of legislation and make sure we get clean jurisprudence out of it. So, Judge, apologies for not directly responding, but we took it as a superb suggestion. Thank you.
Thank you. I wanted to say I'm really kind of happy with the fact that slap suits have gotten a lot more publicity and education. When I was at CALS, we had one of the first slap suits, and because we were being admitted as amicus in an urgent application, the judge didn't even deal with the issue of the slap portion in our submissions in their judgment. And that so often happens when you are an amicus or where it is an urgent application. And so in terms of Dario's point on research, there is a lot of information and a canon of knowledge that is being lost because of the systems and the procedures of the practice of law. So just if anyone does want to take it up as a study, to take a look at those elements as well.
Thank you so much. So I'm asking this question because I see a couple of students in the room, Dario students, in fact. So there seem to be two different approaches to widening this definition or application of SLAB. And I know in recent years, we all know this, that it's become a very useful defense for the chilling effect on journalism particularly. What does that do when we look to other forms of litigation and not emphasize the SLAB defense in terms of journalism in particular?
I wanted to ask whether there's not something definitely wrong with our entire judiciary who allowed Jacob Zuma to challenge Karen Moore on an absolutely ridiculous case that is unbaseable. And how could they dare to have let Karen Moore be challenged in the first place? And how could they dare to let Downer, the prosecutor, that has been waiting for 20 years to prosecute Zuma for the arms deal violations. How could our court allow, all of our courts, the highest ones, allow Jacob Zuma to challenge Downer's integrity as a prosecutor? A prosecutor is allowed to be biased. That's what the judge isn't allowed to do. A prosecutor should be down at bias, shouldn't he? Especially against villains of that description. Thank you.
Yeah, of course.
Hi there, thanks so much. A very quick question. Everyone alludes to the fact that women are proportionally more affected by this, especially when it goes online with the trolls and bots, etc. But what proportion is that? Does anyone know? I mean, is it like 80% of the people who, you know, it's all genders that are affected by slap suits, I gather that. But in terms of the proportion that goes online for vilification, cyber misogyny, etc., obviously it's women, but, you know, does anyone have any research on what is that figure or proportion in South Africa? Thanks so much.
So I'll maybe start with a question on when and when we don't use SLAP. I think it's a strategic decision that litigators and their clients will need to make going forward. You know, alleging that someone has abused court process, for me, is as powerful. I think if we can mainstream a discussion around abuse of process, I think Stalingrad has become quite a useful rallying point. I think there's been some very clear guidance on the discontent that we've seen because of the use of this strategy. But for me, a broader categorization of abuse of process, which is simply an allegation against your opposition that they are not falling in accord with the democratic processes we have agreed to, including the rules of procedure in the judiciary. So I think civil society may have a role to play in further mainstreaming abuse of process as a doctrine. and then siloing out SLAP-specific cases. So we don't diminish the power of SLAP, we simply enhance the power of abusive process allegations, which are very credible. They're allegations that we've had in our common law for years. So I think that may be an argument to that. On research, I can't speak to it. I think there's clearly, from what we see in at least women journalists and civil society actors who have been targeted, a very discernible trend. On a quantitative basis, I'm not aware of statistics, and I think there is scope for wonderful research, both into the psychology of those who slap, but also into the numbers around cyber misogyny. Dario, I'll leave the questions around Morn to you.
Yeah, absolutely. Just also to say to Dinesh that, and the students, that we're lucky, at least in an area of law like defamation, where in the last 2 decades, there have been fantastic developments, which I wouldn't want to minimize by arguing for a SLAP law, as I said at the beginning. And you know, there are many cases where you can flex those muscles. Prior restraint law, for example, you know, where the law for 2 decades has been absolutely clear. I still am astonished that so many prior restraints, I mean, there were like 7 or 8 in the last few months, are brought when we've got very clear law that says, you know, you've got an alternative remedy, and you if, for example, in a sub judice context, if you can't show a real and substantial risk of harm to your fair trial rights, you shouldn't be trying to interdict a documentary. So we've got those pockets of law. We've got a great case, also Justice Majid, in the case that was the sort of sister case to Mineral Sands, which says that corporates who sue for general damages, generally speaking, in public interest cases, may not be able to recover general damages. They might be limited to other remedies. You've got a case, SA Taxi, saying that when you sue for patrimonial loss as a result of a defamatory publication, you've got to prove knowledge of falsity effectively on the part of. So there are great pockets of law in South Africa on defamation, but I think you still need the umbrella SLAP, because we're just seeing this as a trend worldwide, you know, and it's an important part to enhance our democracy. On Morn, I mean, I take your point and the frustration that it expresses. The good news story, though, is that there was a pretty swift victory for Morn. I mean, when I say swift, it was a few months afterwards, but in court terms, I mean, I read today that a judgment was handed down after 2 years, right? So, and that's the exception, I might add. But there was a pretty swift taking of Zuma on getting that application brought to court, dismissed. Yes, he Stalingraded that too, appealing it, etc., but SCA didn't mince their words when they dismissed that appeal. So ultimately, it's a good story. Why he was allowed to bring it in the first place, unfortunately, is a product of our private prosecution laws, which says once you get that nolli prosecute certificate from the NPA, you can then prosecute if you put up security. And we know Zuma somehow was able to put up security of R500,000 to prosecute, and then went about doing it. There are mechanisms within the law. I see that as actually a success story, because there are mechanisms within the law there to say if you bring a private prosecution for an ulterior motive, the accused can have it struck out. And when you ally that with the SLAP developments, it actually is, I think, a success story. I know it's, of course, incredibly frustrating, and Morn's book is a chilling account, frankly, of what she went through and what other female journalists in particular go through when they are challenged in this way. But from a legal point of view, I think it does show the system actually working, albeit perhaps not as quickly as we would have liked. Yeah.
If I can just add one last note on it, I think, you know, as we develop all of these mechanisms with the intent to swiftly dispose of cases that are contrary to public participation, we should be cautious not to move too far across to shutting the doors of access to certain people we dislike, lest those doors be shut against us in the future, right? So I think the goal is to ensure that there can be summary, quick dismissal of these types of claims. There should still be, to some degree, a hearing. We don't want an instance where, without quorum or without hearing, matters are being dismissed, because that will impede over time our access to courts, and it's about finding that very healthy balance. The one exception is, of course, the vexatious litigant who brings the same case 6 times. I think by the latter stages of refiling the same case, doors can be shut, but it's a very thin line that we need to manage to ensure that there is access to justice, but that it is swift for those who need it most. And that, I think, will ultimately be the crux, Dario, of the anti-SLAP law, and how we get the phrasing and the mechanisms for that right.
Thanks, Michael. I just want to respond to that question as well about data and evidence. We're doing some research around technology-facilitated gender-based violence, and so we have the accounts of the journalists and the activists who've experienced these online harms. But we don't have the sort of quantitative data to back up how many women or minority groups are experiencing online harms. And I think as we pursue this path of tech accountability, it is going to become really important for us to build an evidentiary base. So these are the databases that we can, classify and break down. This is how many, people are being victimized online based on their gender or their identity. So it is an emerging area where we do need to add, some effort and work towards building up these databases. But I just want to thank my wonderful panel. That was a really good discussion. And, as much as SLAP suits often target the individual, it is this big threat to our democracy. It does have a chilling effect. But I do feel quite hopeful, post this discussion, that we are on a path to counter this. There is innovative ideas that will help to build resilience like the SLAP platform. And there are networks of solidarity that are emerging. We're supporting journalists, we're supporting whistleblowers. I think it's about how we coordinate this work. And so there is a sort of a collective effort that we all need to make sure that truth never loses its voice. And in the years ahead, as politics start to change and as we get new technologies and AI that start to disrupt our democracies, we have to maintain this resilience and find more innovative ways to fight for corporations and hold people accountable. So thank you, everybody. We appreciate your participation. Thanks for attending this event, and a huge round of applause for my panelists.
Thank you very much. Right, we're going to just get a panel of pictures of you three, please. Thank you very much, and I think a huge thanks to Kavisha. That means applaud. Right. Okay, so I'm sure you'll agree this was a real, we promised you a cracker of a morning, and I think we've delivered. Well, we haven't, but all of these experts have. So thank you very, very much for being with us. We're going to break for lunch now, and what's going to happen is you'll walk out down the path, and you'll go into the actual main auditorium and up a flight of stairs, a little bit of exercise, and there lunch is served. Please do join us for lunch. And then straight after lunch, we've heard from the legal eagles and the experts, the justices, etc. After lunch, you're going to hear from young people, the people that experience these issues, hear what they have to say. We're going to hear some of the results and outcomes of some of the research, and we'll also share with you some of the insights into yet another discussion document on AI and children. And then, of course, there'll be a little bit of a break where you can go and collect your thoughts, do some work in the foyer if you need to, so that we can be back for what will be a fantastically fun evening, the Journalism Slam this evening, starting here with drinks, etc., from 5:36. So please join us for that. But thank you so much to these excellent experts. Thank you for your time and your commitments. Again, thank you, Justice, for being with us and for staying with us. We're going to break for lunch, and we will see you. It is now 12:30. We will be back here at 1:30 promptly. Thank you very much.